I've got more important things.
Hi, everybody. We're going to get started with the third session. For those of you who are just joining us, my name is Diane Hernandez. I'm the editor-in-chief of Tulsa Law Review. And it's my privilege at this time to introduce the moderator for our third panel of speakers today, Professor Melissa Luttrell. Professor Luttrell joins the University of Tulsa College of Law after 2 years as a visiting assistant professor of law at Florida International University. Prior to entering academia, she was in private practice in Los Angeles, where her work included representing hospitals in complex civil litigation in state and federal court. Earlier in her career, she served as legislative counsel for regulatory affairs at Public Citizens Congress Watch. Her scholarship considers the appropriate use of microeconomic principles in legal decisions that relate to environmental and public health risk regulation, the ways that decision makers actually use available evidence in the absence of perfect information, and the integration of idealistic notions of what protective environmental and public health laws can and should do with the pragmatic realities of the world that actually exist. So, with that, please join me in welcoming Professor Melissa Luttrell.
Well, it's my pleasure to introduce Professor Artie Rai, who is the Elvin R. Laddie Professor at Duke Law School. For 2 years, from 2009 to 2010, she served as the administrator of the Office of External Affairs, the U.S. Patent and Trademark Office. In addition to her many years of service as a professor at Duke Law School, she has also taught at some other law schools you might have heard of, such as Yale and Penn. She has quite an impressive academic resume, culminating with a JD earned cum laude at Harvard Law School. And she also has clerked for Judge Patel, U.S. District Court for the Northern District of California. Her research is impressive and voluminous, and I am looking forward to hearing what she has to say.
So thank you very much. I am really honored to be here to honor Professor Elhaeg. Professor Elhaeg is one of these rare polymaths that we see fewer of these days, unfortunately, in legal academia, and we can see the range of his scholarship from the fact that the panel immediately prior to lunch was talking about some of the most sublime and important issues regarding allocation questions, distributive justice, to this panel, which will go to some perhaps more mundane questions regarding antitrust, and Professor Elhaeg is an expert in that arena as well, which is, as I've indicated, just extremely rare these days to have that kind of polymath ability, and it's a real honor to be here. Now, having now introduced the fact that I'm going to be talking a little bit about antitrust, let me throw in several caveats. One is that I'm not an antitrust scholar myself. I actually do patents more than antitrust, so anything I say about the antitrust piece, if I'm wrong, please excuse that. Being a patent scholar more than an antitrust scholar, I will, of course, tailor the talk to the area of my expertise, which is patent law, as you'll see. That's what we law professors do in order to make ourselves seem smart. The other caveat is even the particular topic I'm going to cover, pharmaceutical patenting after FTC versus activists, which is an antitrust case, involves a relatively arcane area of both antitrust and patent. So for some of you anyway, antitrust and patent in and of themselves are relatively arcane subject areas. This is a particularly arcane, but nonetheless extremely important area of intersection between patent and antitrust. And I say all of that in part also because I'm going to give, although I'll try to be relatively brief so that we can have lots of Q&A, I will also give more of an outline / background of the legal infrastructure, if you will, that undergirds the Supreme Court decision FTC versus activists, which was rendered in June of this year, because one needs that legal infrastructure to understand what the issues are. So just by way of outline, my legal infrastructure piece is the Hatch-Waxman statute, which works at the intersection of patent and antitrust, and the history of so-called reverse payments in that context. Reverse payments are so denominated because they're payments from the patent owner to the alleged infringer, which is the reverse of what one might expect in a litigation settlement. Then I'll talk about FTC versus activists, which was a Supreme Court decision that addressed whether these reverse payments were problematic as a question of antitrust law in the patent litigation context, but specifically in the Hatch-Waxman context. Then I'll move over, I hope with some relative expeditiousness, to the area of my expertise, which is the patent system, and why I believe the entire way the system is, the legal infrastructure, if you will, of the system is set up is completely incorrect. And what we really need is a reworking of the entire system. So the antitrust decision, which, by the way, follows the prescriptions, if not the elegant reasoning of Professor Elhaeg, is correct in my estimation. I think ultimately the problem is far deeper than the antitrust decision, and the antitrust decision in some respects epiphenomenal, if you will. And then finally, last but not least, I think even more fundamental, perhaps the pharmaceutical industry simply needs to opt out of the patent system. And so that's my provocative, but I think also relatively grounded concluding thought. All right, so Hatch-Waxman was a statute passed by two senators, Senator Hatch and one senator and one representative, Senator Hatch and Representative Waxman. If you know anything about Congress, you know those are two names one doesn't necessarily see together on much legislation, and this was a grand compromise, as might be expected from a piece of legislation that involves a relatively conservative Republican and a relatively liberal Democrat. It set up a procedure by which generics could enter the market and sell drugs without having to do their own clinical trials. Prior to the Hatch-Waxman Act, for the most part, there is not much of a generic industry because generics had to do their own clinical trials, and without patent protection, the argument went to there would be no incentive to do those clinical trials. So in this situation, the Hatch-Waxman procedure comes into place so as to allow a generic to enter the market without doing the clinical trials, and rather by relying on the clinical trials done by the branded pharmaceutical companies. So the generic files something known as an abbreviated new drug application. In the context of doing that, it certifies that patents that cover the branded drug that are listed on something called the Orange Book, which used to be an actual book that was orange, bright orange, have expired, or more importantly for our purposes, are invalid or not infringed. And the certification with respect to non-infringement and or invalidity is called a paragraph 4 certification. The idea there is that we want or in part at least the rationale for setting this up in Hatch-Waxman was that we want the generic to challenge any bad patents that the branded firm might have. And having been at the Patent and Trademark Office for 2 years as their chief policy person, I can tell you without fear, I think, of seeming biased in the wrong direction, that the Patent Office issues a lot of bad patents. So this is a good thing to challenge bad patents, and the Hatch-Waxman supporters knew that. So if there's a paragraph 4 certification, the brand name can file an artificial infringement suit. There isn't actually necessarily any infringement going on. The generic doesn't necessarily have to launch in order for the brand name to file the infringement suit. It must do so within 45 days, and the launching of this artificial infringement suit gives the branded firm a 30-month automatic stay of FDA approval with respect to the generic drug. So it operates somewhat like an automatic preliminary injunction, if you will. And for a while, prior to certain 2003 amendments, branded pharmaceutical companies were stringing these stays together so as to get extended patent life even on some pretty dubious patents. That was limited by the 2003 amendments in the Medicare Modernization Act that limited them to 1 stay, although they do get that 1 stay automatically. All right. So more legislative infrastructure, importantly, this is a very complicated statute. The first paragraph 4 filer gets an 180-day exclusivity period during which they can be the only generic on the market. And this was intended as an incentive. It was intended deliberately as an incentive by the framers of Hatch-Waxman to bring paragraph 4 challenges to challenge bad patents. One of the arguments being made, and here I'll get to economics speak, I apologize for that, is that challenging a bad patent is a public good because you invalidate the patent as against the world, even though you incur litigation costs only as you incur all of litigation costs yourself. So that public good, the argument went, had to be incentivized itself by 180-day exclusivity period. There was also an interesting argument that Senator Hatch made that even if the patent wasn't invalidated, but the generic determined that its drug could come on without infringing, perhaps the 180-day period was a good spur for the design around innovation that the generic would have to do to make a non-infringement challenge. One of the wrinkles in this legislative infrastructure is that one doesn't have to win the suit to get exclusivity, however. And in point of fact, if the first filer of the ANDA settles, the exclusivity doesn't even transfer to a subsequent filer who is successful either in invalidating or in asserting non-infringement. So there is arguably a bottleneck for generic competition if the first filer settles and determines that it doesn't want to market. So this was an issue that the FTC saw as early as 2000. It's been pursuing this problem of so-called reverse payments that brand names have an incentive to make because they can create this bottleneck situation where they're protected against competition even on arguably weak patents. Unfortunately for the FTC, starting at about 2005, they started to lose all their cases. So the 11th Circuit, the Federal Circuit, the 2nd Circuit all said the payments were okay, these so-called reverse payments were okay, if they were within, quote, within the scope of the patent, unquote, which essentially meant that if the patent had been granted by the Patent Office, you could always make a reverse payment on it, no matter how weak it might be, because the Patent Office had granted the patent and therefore patent law trumped antitrust law. And not surprisingly, reverse payments increased substantially after that time, and according to one study, 70% of settlements in 2012 were of the reverse payment variety. So arguably a lot of shielding of bad patents going on, the so-called evergreening that some of you may have heard of in the more popular press. So again, the argument made by many antitrust lawyers, and in part by the FTC, although not as articulately by the FTC as by Professor Elhaig and his co-author Kruger in a 2012 Texas Law Review article, is one can show that if the payment is above avoided litigation costs, into the future anticipated litigation costs, reverse payments shield either a bad, i.e. invalid patent, or a patent that's not infringed, and one can show this. And as an empirical matter, so Professor Elhaig has a nice mathematical model in his Texas Law Review article, which I commend to all of you. As an empirical matter, Professors Hemphill and Bhavan Sampath have done really excellent empirical work showing that these paragraph 4 challenges are generally not on the core patents that pharmaceutical firms hold, but rather on what they call, and others have called, so-called secondary patents. So these are usually patents on chemical variants or formulations or methods of use. And they typically, having now spoken to a fair number of generic firm lawyers who litigate these cases, it seems like these sorts of patents typically fall into two buckets, and one can tell this fairly quickly if one is a patent lawyer. They're either susceptible to an invalidity challenge, that's bucket 1. They're going to be hard to avoid because the FDA won't let you avoid them and get your generic on the market, but they're usually going to be susceptible to an invalidity challenge, or they're easy to avoid. So either way, they shouldn't deter competition, yet with a reverse payment they can. So this is from a nice summary of the Hemphill and Sampath empirical work that they published in Science magazine in March. It shows graphically that basically you have a lot of situations where, in most of these situations where there have been challenges, they are on secondary patents. These are outcomes for all the paragraph 4 challenges between 2000 and 2008. The secondary patents, if they go to litigation, involve primarily generic wins, not surprisingly. Secondary patents tend to settle a lot more, and a lot of those settlements are so-called reverse payments. By contrast, the core patents, the active ingredient patents, many fewer paragraph 4 challenges on those, only 55 as compared to 222 on the secondary patents. And if they go to litigation, the branded firm usually wins. A bunch of those do settle as well, and I'll talk about why those settlements might be occurring. They don't involve reverse payment quite as much. So the FTC versus activist case was a case that the FTC finally got the Supreme Court to take after several attempts to get the Supreme Court to take one of these lower court decisions where they had been rejected on their argument, again, not made as eloquently as Professor Elhaig makes it, but essentially saying that these reverse payments are shielding bad patents or non-infringed patents. And they argued before the court that a reverse payment is essentially a horizontal agreement to suppress competition under Section 1 of the Sherman Act. This is the U.S. government arguing on behalf of the FTC. Interesting side note, DOJ and FTC were not in agreement during the Bush administration. During the Obama administration, they came into agreement, which is probably one of the reasons the Supreme Court took the case. They make the point in their brief, the U.S. makes the point in their brief, that the reverse payments disturb the alignment of the generics incentive to promote the public's interest in access. Because they basically promote or take away the generics incentive to bargain for the earliest entry date possible given the relative strength of the patent. Ordinarily, the generic would have an incentive to do so to maximize its own profits, particularly given the 180-day exclusivity period. With a reverse payment, that alignment is disturbed. Okay. Bunch of other more technical arguments. They said, the U.S. argued that these payments were presumptively anti-competitive under the so-called quick look rule of reason. The presumption could be rebutted, according to the U.S., if the consideration in the reverse payment was for unrelated property or services or equal to avoided litigation costs. The U.S. also made the point that reverse payments are, quote, virtually unknown, unquote, outside the Hatch-Waxman context, and this is because the settlement with the first filer buys peace in the patent, buys patent peace, if you will, even with respect to a bad patent, because no one else really has an incentive to challenge the patent. No one else can get the 180-day exclusivity. Although there's a little bit of I think that last piece is a little more, that argument is a little more dubious because there have been, according to the FTC's own numbers, 26 products with more than one reverse payment. So one reason you might anticipate just, as a matter of common sense, why we wouldn't see more reverse payments and more patent settlements generally is that it represents an admission perhaps that your patent is weak. So lots of other infringers might come to you and say, pay up. If you paid up to Challenger 1, pay up to me too, and so forth. So the difference in the Hatch-Waxman context is you can buy patent peace with just one settlement, said the U.S. government. Again, not entirely the case, but that was their argument. All right, the alternative positions, the activist approach was the so-called scope of the patent approach, which I think is on its face a pretty bad argument, because if we know that the patent office is granting bad patents or patents that aren't infringed because they're so narrow, we shouldn't allow those bad patents to exist in the marketplace and prevent competition simply because they've been granted by the patent office. There's another argument that Professor Elhaig takes on in his 2012 piece, which is an interesting one, and he does a good job of showing why it's difficult to take this position, that the antitrust court should assess the objective or perceived likelihood of patent validity or infringement in the antitrust case. And as Professor Elhaig nicely points out, it's going to be very difficult to ask an antitrust court that is trying to promote settlement, because in general we like to promote settlements, to go into that inquiry and spend all those resources making that making that inquiry, and then also once they've reached a conclusion on that inquiry, kind of posing the counterfactual question, because the inquiry will probably lead them to conclude that the patent is either invalid or valid, then come up with the counterfactual of, well, but how would it be objectively thought of at the time of settlement, as opposed to how does the court think of it then? So I think all of these are good. These are alternative positions that Professor Elhaig soundly rejects in his article, and are good. It's good that the Supreme Court rejected them as well. And what the Supreme Court did, although it nominally rejected the quick rule of reason approach advanced by the U.S. government, it did perhaps go along with a large piece of that approach by saying that the antitrust court looks on a case-by-case basis at the size of the payment, and if the size of the payment is greater than the payer's anticipated future litigation costs, there's probably a weak patent there. One looks at independence from other services for which it might represent payment. Those first three factors take us very close to what the U.S. government was advocating. The fourth factor is where I would call it the fudge factor. Justice Breyer threw in this lack of other convincing justification, and no one knows what that means, which is why I think, unfortunately, the opinion is not as clear as it could be. That said, we have now a little cottage industry of antitrust commentators deciphering the case for the lower courts in case the lower courts are, as they're likely to be, a little bit confused by what the Supreme Court intended to say. So various commentators have, including Professor Hemphill, who was heavily involved in the case, have issued kind of their opinions regarding what the Supreme Court opinion says. And they seize on this particular paragraph in the opinion where Justice Breyer says, the owner of a particularly valuable patent might contend, of course, that even a small risk of invalidity justifies a large payment, but be that as it may, the payment, if otherwise unexplained, likely seeks to prevent the risk of competition. And as we have said, that consequence constitutes the relevant anti-competitive harm. Sorry. So according to these commentators, they include Professor Cotter, Professor Hemphill, Professor Shapiro. Carl Shapiro is an antitrust economist at Berkeley, Professor Aaron Edlin at Berkeley. So, a fairly reputable cast of characters. The court is essentially saying here that any payment above litigation cost is suspect, that no separate power, showing of market power is necessary, no need to litigate underlying patent validity, and risk aversion, which is often trotted out by the pharmaceutical firms as a reason that they sometimes make reverse payments even on patents that they think are really strong. According to these commentators, the court is not allowing risk aversion either to be a reason to accept reverse payments. Now, I hope they're right. I think that would be an appropriate position. I'm not sure FTC versus Actavis gets us there. But let's assume, for the sake of argument, that that's what FTC versus Actavis means. And as I said, I think that's probably a good way to go as a normative policy matter. Even so, I still don't think bounty-driven, and I would call the 180-day exclusivity a bounty-driven litigation schemes are the way to deal with this issue. Obviously, there's the expense of litigation prior to the settlement, and for better or for worse, there's probably going to be some further elucidation of information that's going to happen before the settlement, just because without a claim construction, and that's a term of art within patent law, it's going to be hard for the parties in question to have the same estimates of the patent validity. But more importantly, and this is where I put on my patent hat, I think litigation has a very, very significant risk of inaccuracy in this context, particularly because of the role of juries. And there's a lot of literature on why juries are not a good idea in the patent context, and I think they're a particularly bad idea in this context. There's a good administrative law argument. I also teach administrative law, argument to be made that Professor Duffy tried to make to the Supreme Court, but they didn't bite it for a cert petition, and bite on it for a cert petition, that juries shouldn't, as an administrative law matter, have the power to adjudicate what the Patent Office has done already. So in any event, so I think juries are a big problem here. And Professor Elhaig has made the nice point that settlement, even without reverse payments in litigation, may be suboptimal from a social welfare standpoint, and you can read his article for the very elegant demonstration of why, but I'm convinced by that argument as well. So I think that this whole system is fundamentally broken. So, for example, there should be no reason, in my estimation, for the 67% of cases that are litigated to a final judgment in the active ingredient context to have to go that far. That just seems to me likely to lead to delayed generic entry, or an inaccurate resolution. On the secondary patent context, the delayed generic entry is even more problematic because the patent is likely to be invalid. And so it seems to me that what we need is an administrative approach, and I teach administrative law, so not surprisingly, that's my view. The intuition here is that patents don't need to be probabilistic. So in the patent literature, we hear a lot of discussion. Carl Shapiro and Mark Lemley coined this term a long time ago. The patents are inherently probabilistic, and therefore nobody really knows whether a patent is valid or invalid until they really examine it. It's sort of like quantum physics. You don't know whether something's a particle or a wave until you look at it. Here, though, we don't need to operate in this vague realm of probabilities. We've got a very small number of Orange Book patents every year. The reason we generally have to operate in this realm of probabilities is because the Patent Office issues 250,000 patents a year, 250,000, most of which don't matter. Maybe 1 to 5% matter. So in general, we don't want to do re-examinations, which is something you can do at the Patent Office on most of the patents the Patent Office issues. But these 250 OB patents are likely to be pretty important. In fact, I would say that they're almost by definition pretty important. So if you do a re-examination right away, if the patent is upheld, even if that's not an automatic, it doesn't automatically result in the patent being completely bulletproof in a court setting, it certainly provides lots of information going forward to the parties that might subsequently litigate. And even if it's not just a question of validity, but also a question of infringement, you do get a claim construction out of a re-examination. Now that's really getting into the weeds of patent law, but suffice it to say that you get lots of information very early on into the system, so this quantum physics approach doesn't need to be utilized if we do re-exam. And that's a very cheap way of doing things. It's about $50,000 per re-exam at the high end. Now, that would be the optimal solution, I think, if we're going to go with this administrative approach. There's also, and for reasons of time, I'll go through this quickly, there might be some reason that certain pharmaceutical firms might prefer an alternative administrative approach that would involve re-examination only at the time when the paragraph 4 challenge takes place. That may also be better from a social welfare standpoint because you have an adverse party, a concrete adverse party, to bring the best argument against the patent being valid or not infringed at that point. But either of those two approaches strikes to me as superior to a litigation-based bounty approach, which I think is quite faulty. All right, I have 3 minutes, and I will make my last point, which I think is the most interesting. There's some other features that we can talk about that would be involved in an administrative approach, but not necessary to get into that kind of level of weeds. Unfortunately, the real world after activists and the American Invents Act, which does set up these re-examination proceedings, is not going to be nearly as clean as my optimal administrative procedure system. We do have a little bit of this going on already, so it's early days. Let's hope that the administrative approach takes a firmer hold, even though it currently, because of the way the American Invents Act, which I was helped do policy analysis on, so I do have some bias there. Even so, the American Invents Act is not optimal in some respects with respect to the administrative procedure set up. But let's hope it creates a greater momentum towards administrative approaches. All right, so this is my final slide, and here I do think that there is going to be some momentum in Congress fairly soon. I'm having a conference just to let you know, in November in DC, making a case for this along with several other foundations or organizations. I'm not sure the patent system is worth the candle anymore for the pharmaceutical industry. It's really not clear how well it works. Ben Rowan at Harvard, Professor Elhaig's colleague and Professor Cohen's colleague has noted the problem of unpatentable drugs. There's going to be a very strong patent push from the pharmaceutical industry because of the FTC versus activist case, probably reducing their effective patent life to question how well the patent system is working for them. The reason total exclusivity for pharmaceutical firms has remained stable at about 12 years, and this is what Hempel and Sampat have shown, is because of these secondary patents. So they're bad patents, but they do have the effect of keeping the total exclusivity for small molecules relatively stable at about 12 years. Biologics, which are another type of therapeutic, got 12 years of data exclusivity in the Affordable Care Act, going back to the Affordable Care Act. And I think part of the reason was, and I've written a little bit about this, is that there was an unpatentable biologics problem as well, and the consequence of that, which I don't think 12 years was necessarily optimal, but they got 12 years in the Affordable Care Act. Small molecules, by contrast, have 5 years. There's no particular reason for that disparity that I see. In general, it seems to me that there's no reason for the disparity. Europe doesn't have it. And more importantly, in general, it seems to me that what we want, and this goes back to a higher level point to some of the material that Professor Robertson presented this morning, what we really want is reward based upon research risk and disease impact. And there's nothing in the patent system currently that gives us that. And so it seems to me that we need to set up an exclusivity system, and there are lots of devils in the details here, an exclusivity system that gives us reward based upon research risk and disease impact. And that's what the November conference is going to be about. And you'll be all spammed with advertising about it in the near future. Thank you.
Okay, great. Well, it's now my pleasure to introduce Professor Richman, who is also a professor of law at Duke University School of Law. He earned his bachelor's degree from Brown University. He then studied biblical and Talmudic studies in Jerusalem. He earned his master's and his PhD from UCal Berkeley, and he earned his JD 9 cum laude from Harvard Law. Prior to entering law school, his activities included serving as a visiting lecturer in economics in Hanoi. He also worked for the International Trade Committee of the U.S. Senate Committee on Finance for several years. After law school, he clerked for Judge Selya on the United States Court of Appeals for the First Circuit. And he has also an unbelievably impressive set of publications that are pretty amazing. So with that, welcome Professor Richman.
Thank you for the generous introduction, although if I would admire, I'd like to at least equal the threshold set by the PTO, where 5% of what I do actually has a consequence. So that was a very generous introduction. To fill in the biographical information, I was a student of Einer's at Harvard, have been a mentee of Einer's, a long-time admirer of Einer's, and a lot of my work, I should scratch that. All of my work fills one of the many subcategories of work that Einar has. Einar does lots of stuff that I don't do, but all the stuff that I do, he does. And in that sense, his work, at least subjects of his work, has been enormously influential. And what I'd like to talk about today is one area of his work that actually does not have any exclusive connection to the healthcare system, but has a lot of implications for the healthcare system. Einar has been recognized in addition to being a moral philosopher, in addition to doing constitutional work, in addition to doing lots of work on the healthcare system, also is one of the nation's leading scholars in antitrust law. And recently, very recently, Einar has taken on what in many respects is kind of I won't say it's but he's taken on the establishment in fighting a fight that really has needed to be fought for a long time. This is on the doctrine of tying. So a very brief introduction or background for those who have forgotten their antitrust law. Antitrust, one of the sections of the antitrust law of the Sherman Act that was passed in 1890 prohibits certain conduct by monopolists. Monopolists that have a certain market dominance or market position. There are certain things monopolists cannot do. And one of the things that generally fall in the category of bad monopolist behavior is tying. That is, if a monopolist has monopoly power over one product, they are prohibited under certain circumstances from bundling that, from tying it with another product. The classic example is if a monopolist on a person that has monopoly, a company that has monopoly in the supply of bolts cannot tie nuts. Of course, the two go together, and it would be a problematic tie. There was a reaction to this rule. To a large degree, its roots came out of the Chicago School of Antitrust, which was a very significant revolution starting in the 1970s, that started to apply some more rigorously applying the laws or the logic of economics to antitrust laws. And the critique goes as following: wait a second, I'm not really sure this whole tying prohibition is a good idea. After all, there is only one monopoly profit. That is the foundation of the critique. If a monopolist has a monopoly over the supply of bolts, there is nothing to benefit by tying it with nuts that are competitively supplied. The monopolist is not gaining any additional profit. There's only one monopoly profit. If the monopolist only has one monopoly, then tying other goods that are otherwise competitively supplied does not increase that monopoly profit. And therefore, if they are tying, they must be doing it for only good reasons. And there are no anti-competitive consequences, and therefore we should not enforce vigorously, or really at all, the prohibition on tying. This, I think, to some degree had become, maybe not the prevailing wisdom, but certainly was a critique of the tying rule that gained a lot of support, a lot of momentum. And some recent, would you agree with that? That essentially the tide has been moving in that direction. And in a very, very significant article in 2009, Einar said, look, there is a misconception that there is only one monopoly profit. Very often there is more than just one monopoly profit, and because of that, when there is tying, there really is competitive harm going on. A monopolist, by tying another good, tying their monopolized good to a good that's otherwise supplied competitively, really is inflicting economic harm on the marketplace and on consumers, and there are a whole bunch of reasons why. The key insight that he had, I think, can be summarized in the following. Yes, a monopolist that monopolist over bolts is not doing any harm by tying it to nuts, but that is the exception. And the rule, actually, is that is the exception to the rule that in general really is problematic. Very rarely do you have a one-to-one product, monopolized product to competitively supplied product tie. More often it's more competitive than that, and in those situations there's real threat for competitive harm. So in that 2009 article and in some recent exchanges, Einar really has been pushing this rule, I think extraordinarily convincingly. It has been met with what I would say is unsubstantiated or inadequately substantiated resistance. So this is an academic debate that is going on right now. It has real implications for the practice of tying law, the practice of antitrust law. And my paper, which is co-authored, and I want to emphasize that in a moment. My paper says, look, there is a lot of this debate really has taken on in the realm of theoretical models, which is extraordinarily important for antitrust law. In large part because looking at empirical efforts to support the utility or the usefulness of one antitrust rule versus an alternative really is a very complicated endeavor. And a lot of antitrust law as far as the legal development theory, what arguments about what the law should be, really happens in the world of economic models and conceptual arguments. This paper looks at a particular industry, the computer industry, which is, I think anyone would recognize as an extraordinarily important industry, and it looks at one company, IBM, which everyone I think would recognize an extraordinarily important company in the development of the, over the last century of the US economy. And it looks at a series of efforts by the Justice Department to essentially apply the time rule, prohibit time to IBM. And my co-author, Steve Usselman, is a business historian. His expertise is he is the historian of IBM. And really, it was, this paper was born out of a conversation that I had with Steve when he was visiting Duke. He's telling me about his research. I said, you know, your history, 100 years of, maybe 80 years of IBM history, really can inform very meaningfully on a policy debate that's going on right now. So what this paper does, very simply, is look at certain interventions, certain policy initiatives by the Department of Justice to require IBM to unbundle some of its services, and it looks at the consequences of those interventions. And the paper argues that this is history. You know, we're looking at one case study, an important industry, an important company, but nonetheless, we see that there is extraordinary economic benefits that accrued from the Justice Department in these particular initiatives. So, a little bit of background on IBM. There were 3 antitrust initiatives against IBM, one in the 1930s, one in the 1950s, and then one that began in 1969 and really went through much of the 70s. It ended in a consent decree in 1982. All of these initiatives challenged what really is IBM's foundational business strategy, which is to develop, to supply comprehensive business services. So the IBM strategy, starting really with Thomas Watson Sr. in the 1920s, 1930s, is to provide comprehensive services. They have salespeople going to business clients and say, look, we have a whole bunch of things that can help you. We have computers, we have technology, we have know-how, we have salespeople, we have experts. If you give us a certain fee, we will help you with all of our stuff. It's a one fee for a bundle of services. In the 1930s, incidentally, by the way, Thomas Watson Sr., I say senior because he was succeeded in the company by Thomas Watson Jr. Thomas Watson Sr. Actually went to jail for a while for an antitrust violation before he was actually running IBM. He was very hostile to antitrust interventions and really fought tooth and nail. In the 1930s, the first antitrust intervention by the Department of Justice was with IBM's tying of its accounting machines with its punch cards. So accounting machines are, back then, they weren't really necessarily computerized, they're mostly mechanical. But they were devices that used punch cards where you entered the punch card in the data, you threw it through the machine, and the machine would process the data for you. So normally you would buy one processor, often you would lease it, and then you would purchase the punch cards individually. And IBM essentially said, look, you have to buy our punch cards if you buy our machine. It's a classic tying. And I think most would argue that this is a tie whose design is to price discriminate. The people who use the machine more would use more punch cards, and therefore the high users, the people who value the machine more, would pay more. There is a debate as to whether this strategy of tying is really a good thing or a bad thing. I will say that I'm unconvinced that the history of this intervention really has a lot of consequence. Maybe Hunter would be able to clarify something on this a little bit. But after the intervention, which essentially prohibited IBM from bundling its accounting machines with its punch cards, required to sell its punch cards separately, or really required it to sell its accounting machines separately, where anybody could buy an accounting machine and then buy punch cards from wherever they wanted. It didn't really reduce IBM's market share. In fact, IBM's market share grew, in large part because I think the industry grew, accounting services, the demand for accounting services really swelled growing into World War II. But IBM's economic power really was not diminished by the prohibition on its tying. And maybe that means that enforcing the rule doesn't really impose any inefficiencies. Maybe it means that although the criticism on prohibiting or preventing price discrimination is that you reduce output, maybe this is an argument that actually prohibiting it really did not reduce output, although it's hard to actually think of what the counter positive would be. But there seems to be very little learned, really, from the imposition of that, or the initiation of that suit in the 1930s. All right, the next two are a little more interesting. In the 1950s, the Antitrust Division in the Justice Department, this, by the way, led to a 1956 consent decree, was really scrutinizing IBM's bundling of more sophisticated machines with services. Now, it's pretty clear that IBM, and this is from internal records that Steve Usselman has unearthed, it's pretty clear that IBM was advancing a strategy that is defensible on antitrust grounds, at least. The strategy is this: we want to bundle our software and hardware services, our CPUs, our central processing units, with all these ancillary devices. And the reason is because we want to be really flexible. We want to go to our individual clients and be able to meet their needs with all of our different services. And again, we want to maintain this business strategy of having a one-fee consulting services for everything that our company can offer. This was bundling, of course. It was bundling the CPU unit with a whole bunch of ancillary services. It was also bundling with other hardware services, the CPU with know-how, with repair services, with printers, with other ancillary hardware devices. And the 1956 consent decree required IBM to do the following. First, IBM was required to sell and lease its products and its parts, and to license its patents and technologies. So again, previously, everything under IBM's control. And the only way you would be able to get access to IBM know-how was by engaging as a client. Now, IBM was required to sell and lease its hardware, and everything that came with it. It also, the consent decree also required IBM to set up a new entity. It's a wholly owned subsidiary called the Service Businesses Corporation, SBC. SBC was essentially, you might say, the first unbundling of hardware with something ancillary. The notion of software really hadn't been developed at this point. But SBC was essentially an outlet. It was a service provider that used IBM's products. Even though it was a wholly owned subsidiary, it was a new way of providing IBM services. You would go to SBC, and they would have IBM equipment all around, but you would be purchasing only their services. So really there was a division, a forced division between the hardware and all the services, all the benefit that came out of the hardware. So that was the consent decree in 1956, that IBM, it really restricted the way IBM wanted to market its services, and also it created a little bit of an outlet for another business model. So what happened? Well, SBC grew. It was very desirable for consumers to have the ability only to purchase services as opposed to all the hardware. But it's not clear that SBC's market grew in extraordinary proportion. It's possible that its growth just reflected the business that IBM lost. It's also, another thing that happened also is IBM's business model still seemed to succeed. That is, the tied model, to the degree they still could do this, still seemed to be attractive to a lot of consumers. But there was some other really interesting that was happening. With the development of SBC, IBM also made investments, and SBC also made lots of investments in what was really kind of a new market on programming. There was a sense that developing applications for this hardware, this stuff, there's a lot of things you could do with this stuff. And once people had access to this stuff, there was a market to essentially find out what those new applications are. And IBM recognized that, and SBC recognized that, and there were enormous investments in this emerging new market that really was forced upon the marketplace by the consent decree. IBM invested a lot in new division of programmers, in new data centers, which in many respects kind of competed against SBC, that was offering data processing and other services, other standalone services. But what's really fascinating, and it's very consistent with the theory of why we want to have a vigorous tying law, that is a pro-enforcement one, is the consent decree really allowed the development or the emergence of other business bureaus, other service bureaus. So lots of people saw what SBC was doing and mimicked it. To a large degree, if you just look at what SBC did, that's not really telling you a whole lot. If you look at the whole marketplace, you see a wealth of intermediaries. Some people actually criticize SBC for not erecting market barriers. But there was this whole market that grew of intermediaries, users of IBM hardware technology, and developing a whole bunch of new applications for it. And what's especially important about that is wasn't just a natural outgrowth of dividing it, but it was a function of the emergence of the new market and the ability of new programmers and new users to really invest in understanding what those new possibilities were. So you saw a real injection of dynamism in the market. You saw all sorts of specialization of uses of computer uses, the growth of intermediaries that in turn developed new services markets, new software markets, and to a large degree you saw a new profession of programmers that really developed out of this consent decree. So, consistent with what Einer's been saying, inconsistent with the single monopoly profit, there are a lot of dynamic innovations, dynamic efficiencies that can come out of enforcing tying law. And we see a lot of evidence of that in the 1956 decree. The third chapter, the first one is the 1930s at punch card, and the second one is these services from the hardware. The third one began in 1969, and it was brought by Ramsey Clark on the final day. Andrew Clark was the Attorney General at the time. On the final day of the Johnson administration, and it was persisted through the Reagan administration. So this was not this I guess had some bipartisan support. And what's interesting about this is that not only was it brought at a very high level, but the chief counsel of IBM was the former Assistant Attorney General from the Antitrust Division. So you had some very smart, very knowledgeable lawyers on both sides really working at the highest levels of antitrust policy. And this was under not Tom Watson Sr., but under Tom Watson Jr. I should have actually mentioned the previous suit was against Tom Watson Jr. also. Tom Watson Jr., much to his father's chagrin, was very collaborative with the Justice Department. He recognized that, look, this is a constraint we really have to work with. To a large degree, that's why Tom Watson Jr. was, for the most part, fairly cooperative in coming up with the consent decree in '56. And through the 13 years of litigation, there was a frequent communication, a conversation going on between the IBM lawyers and the Justice Department lawyers, and trying to figure out a way to essentially avoid mutual destruction. So what was it that the Justice Department was worried about? Well, in the mid-60s, IBM produced its System 360. In many respects, this was the Tom Watson Jr. signature initiative. Some people say that it was one of the most significant business developments, business strategies in America in the last 100 years. It, as much as anything, revolutionized the computer industry in a way that benefited the innovator. So in some sense, it's not just innovation that's uncaptured. This was really innovation that was captured. The System 360 offered a new possibility for intercompatibility among computers. So there were a whole bunch of things you could do with this same computer. It was a very versatile computer. But because of its versatility, because of its interoperability, it established its own platform, and Justice Department was really worried that IBM would lock out everybody else on the hardware market. So here's a little bit of an irony. The Justice Department in the 1956 decree, or the investigation, was worried about the development of ancillary markets, that is, IBM was monopolizing the hardware market, had a monopoly of the hardware market, and was tying all the ancillary markets that would not allow the development of the ancillary markets. And the Justice Department was worried about that, and it proved to be right, that in fact, after the tie, there was an enormous growth in that ancillary market. In the 1960s, late 60s, the Justice Department was worried about the hardware market getting locked in, that no one would be able to break in. So again, there was a demand to unbundle hardware and software. Software, I think then, is a little more of an intuitive idea than for what we have now. And again, it not only unleashed a lot of dynamism in the hardware market, but again, really, even though it wasn't really the Justice Department's intent, it also unleashed a lot of dynamism in the software market. What happened to IBM during these 13 years? Again, this is where the historian really comes in. Steve looked at the internal memos and said, even through this conversation between the IBM lawyers and the Justice Department, because of that conversation, because of pressure from the Justice Department, IBM did change its business strategy. And but for the intervention, but for the tying claim, would not have let go of the software industry as it did. So what happened? There was, again, enormous software development outside IBM walls. There were a lot of what was called S360, System 360 emulators, which allowed other hardware manufacturers, Dell, Wang, to produce hardware, use computers that then use S360 software. So not only did you open up the software business, but this was really what the Department of Justice was really hoping for, it really opened up the hardware business also. And in a very interesting twist that Artie would play, a lot of what came out of this conversation is whether or not we should copyright software, whether software should be subject to the copyright laws. And originally IBM was saying, our concern is only with the hardware market. But then once there was an unbundling, there really was a growth not only of software development, but also of software and intellectual property rights. We see in at least two of these three initiatives enormous economic benefits as a consequence of the antitrust initiatives. Again, the historian analysis is the Department of Justice is worried about certain things that IBM did, worried about certain tying elements, certain bundling practices that IBM was doing. For those reasons, it brought those suits, hoping to unbundle and hoping to open up the markets. And critically, but for those suits, IBM would not have changed its business practices. And I guess number 4, and really good things followed. That is the syllogism that we see in these two examples. Steve makes an additional argument, which I don't really buy. He doesn't really buy it either. But that maybe IBM was so convinced that bundling software with hardware was impossible that when it developed the PC in 1982 in Boca Raton, it decided to pursue an open architecture that allowed Microsoft and Intel essentially to capture all the gains. And perhaps, he says, were it not for all of these tying claims the 40 years earlier, maybe IBM would have tried to pursue a closed model, and we wouldn't see the PC boom that we have. I don't think there's evidence for that, but never mind. So let me say, because this is a conference that is focusing to some degree on Einer's contributions to healthcare policy, let me close by saying that this is a significant historical case study. Only a case study, but I think a very significant one that really adds empirical heft to Einer's argument on tying, when there's, I think, very little empirical support on the other side. I think for that reason, it's I think a modest, we don't want to extrapolate, but at least a very significant case study that supports the benefits of really enforcing tying law in the way that Einer suggests. And I think that this lends very significantly to a lot of the work that Einer's done in the healthcare market, the healthcare services. There is a lot of tying going on by monopolists, by provider monopolists who say, look, we have the only surgical center in town, but you have to use all of our primary care doctors, you have to use all of our radiologists if you want to have surgery in this hospital. And frankly, a lot of insurers also really bundle services in ways that don't really benefit consumers. And I think there's a lot of evidence to suggest that tying in the healthcare market really is extremely, and maybe even exceptionally costly. There's evidence that the thing that makes the United States unique in terms of healthcare dollars is our prices. We charge too much. The prices that providers charge are often significant multipliers of other prices, similar prices that in other OECD nations for services that by all accounts are of equal quality. And the tying strategies by providers really is an effort to expand the monopoly profit. There, as much as anywhere, there is not a single monopoly. And there, as much as anywhere, the tying efforts among providers especially really is an effort to expand monopoly profits. And it is a real area where there is greater need for tying enforcement. To some degree, a lot of this is implicated with the development of the accountable care organizations, which in many respects is one great big tying strategy. We are seeing the kinds of consolidation and tying strategies that really could make the development of the ACOs and the consequence of the Affordable Care Act really costly. But on the other hand, with the exchanges, hopefully with the dynamism of certain insurance products and the entry of new insurers, maybe these purchasers, third-party purchasers, really can arm themselves with tying claims and really try to break up monopolized services. There is a real possibility that a dynamic insurance market using tying claims can bring a lot of dynamism and bring some significant cost down to the healthcare services. So this is an extraordinarily important doctrinal debate, very, very important for antitrust writ large, I think extremely important for health policy. And to the degree that history can help, I am very eager to make sure it helps, because the policy certainly is right. I had here's my one final comment. It's really a question. I can't decide what to make the title of this paper. It's initially Vindicated by History, L. Haig on Tying. Another possibility, of course, is L. Haig on Tying, Vindicated by History. But I'm looking for something a little bit more dramatic, like, how to break up monopolists. This is the only chance we have.
Professor Rye. So, Artie, I'm more or less sympathetic to your more provocative conclusion at the end, and I want to ask a sort of provocative follow-on question from that. So, if it's the case that either because the patent system isn't working terribly well in pharma, or that pharma's need for recouping R&D risk is best or can also be served by exclusivity periods, what does that do to patent law and policy generally in the following sense, which is that, historically there's always this argument that the general case for patents is indeterminate because there are costs and benefits and administrative costs and transaction costs. Maybe we get some more innovations on the margin, but maybe we restrict too much access otherwise. And it's very complicated and indeterminate everywhere but see pharma. So this has been sort of the history of the literature for 40 years, let's say. So you're proposing in November to drop that footnote. So there is no but see pharma anymore. There's just now, the case for patents is now really indeterminate, uncertain. So I actually think this is kind of important in terms of general IP theory, and maybe its intersection with antitrust, which is, what does that do for the general case, for the big worldwide debate that always seems to keep happening? Pharma is what made the case for patents airtight in a way.
Right. So I see that as a feature, not a bug.
Right.
Right.
Okay.
So that's my. This is being recorded. I guess.
That's why this is why I'm asking.
I see it as a feature, not a bug, because it seems to me that pharma described broadly, including biologics and maybe medical devices, is a special case. And once we get that out of the system, it seems to me that we can have a much more rational debate about patents in general. And it seems to me that then the arguments for patents and shorter patent periods become very, very powerful. There are shorter patent periods within patents.
Well, I'll ask a question of Professor Richman. About the ACOs, and I definitely take your point about there being some sort of monopolistic tendencies there with regard to sort of tying. But there's also some savings associated with ACOs, right? And sort of that's why they're being endorsed under the ACA, with the idea that, you know, the information, the ability of information to move freely, the cost savings that would be there, the connections of the doctors to each other for the informal consults with the related patients. So the idea was, so, you know, in your mind, you sort of come to the conclusion that the tying problems outweigh the other benefits of ACOs?
So this gives me a chance to highlight another feature of Einer's work. So Einer edited a very important book that identified the fragmentation of the healthcare delivery system as being a really severe cost, a real problem. So let's start there. That fragmentation is a real problem. We have, although we have market power, an excess of market power for individual services, none of those individual monopolists talk to each other. They order duplicative tests. They don't communicate, and not only does it lead to excessive care, but really bad outcomes also. It's a real problem. One of the policy solutions is the accountable care organization. This is a way of trying to fix the problem of fragmentation. Okay. So first of all, although it is, I think, undisputed that fragmentation leads to real costs, and that other systems that are more integrated, Kaiser, Geisinger, Intermountain, all the ones that were trumpeted out during the Obamacare's passage, exhibit better outcomes at lower costs. There is not, unfortunately, evidence that the accountable care organizations are achieving those same savings. And the results from the pioneer ACOs really are kind of mixed and deeply disappointing. So we have a problem. The accountable care organization is the proposed solution, but there's very little evidence that it's solving the problem. And one reason, I think, is because, there may be two reasons. One reason is because the ACO, to a large degree, is a sledgehammer trying to kill a fly. There is a lack of communication. There is a lack of coordination. So what do? Well, let's just have one hospital buy up everybody. It is a little bit surprising that it doesn't improve communication, but it is deeply surprising that people would think that that is the best way, the most efficient way, especially in a country that still believes in the value of a competitive market, that is the best way to encourage facilitation. I mean, you take the computer example. I mean, I have an Apple laptop with Microsoft products, a Gmail account. I mean, these are big companies that figure out a way to communicate with each other on domains, technological domains that are a lot more incongruous and complicated than just figuring out how to communicate personal electronic health records. And they haven't been able to do that. I think a real problem is because you still have, on the provider side, you still have this monopolist mentality. You don't have incentives to pursue value creation and to try to address the problems that Einer scholarship and fragmentation really identified. Instead, you have it's like a utilities strategy. You just buy things. You try to control things, and that has both proven to be ineffective at achieving the efficiency we were hoping it would, and it really is a real problem. It's expanding market power in a market that converts market power into some very, very significant price increases.
Other questions?
I was hoping the CEO from the local hospital would chair the board would respond.
I'm not a CEO, I'm a board member, but the thing I will tell you about is that we were selected several years ago to run a demonstration project with regard to bundling services for particular types of conditions. What it involved was on the cardiac side and on the orthopedic side. And in that particular instance, we entered into a contract with CMS for a specific fee that would cover everything with regard to specific types of care. For example, if you were doing a stent or a valve procedure on the cardiac side, obviously we didn't own the device provider, the stent maker or the valve maker. The hospital did have a relationship with the doctors. And what happened was, under the hospital receiving a fee, then it encouraged the three entities, the hospital, the physician, and the device maker, to work together to see how you could deliver the services, because any savings, we were permitted to split among ourselves. And it did create an incentive for the device providers to bring their prices down for surgeries that took place involving these particular activities. And it did work. We did accomplish savings by working in such a cooperative fashion, and there was money that was provided. I frequently see the amount of money that goes to the physicians. The last payment I signed was for like $79,000. The feds tried several hospitals on this demonstration project. We were the first that got up and running. And to the best of our knowledge, we're the only ones that actually made it work. And I think part of what is an indicator is how a provider is actually doing business, their business practices, as to whether or not that particular type of an arrangement is going to work. Some hospitals, they just couldn't make it work in the business culture that they were engaged in. And the physicians couldn't make it work based upon how their practices were structured. So that's kind of part of the challenges of trying to find the savings. CMS said, this is how much we want to pay for this. Now you figure out, can you make some money doing it that way? And we did figure out that we could make money doing that way, but the demonstration project also showed it didn't work, generally across the country.
Do you have any questions? Well, if no one minds ending 3 minutes early, I want to thank our panelists. Once again, those were fantastic presentations.